Wyoming conference, where Brian comes from as well. One church in Binghamton, New York. I served a church in Wilkes-Barre, and most recently I had 7 years in Harrisburg at Chambers Hill. And now have transitioned to work with a foundation full-time, still under appointment and working there. I have just a few slides to just tell you in general about the ministries of the foundation, so just to share with you a little bit there. On the Western PA side, we were founded in 1970. That's a few years earlier than we got going in the Susquehanna Conference or the Central Pennsylvania Conference a few years after that. We are a member of the National Association of United Methodist Foundations, which gives us a nice big network to share ideas and follow best practices and have some accountability with foundations all across the country. We are separately incorporated from the annual conference, so when you say the conference, that's not us. We are a separate organization, but we are incorporated to be a supporting organization of the annual conference so that we can work with agencies or churches or any United Methodist related institutions that are in the bounds of our 2 annual conferences. So the idea of a foundation is that we believe we can get more done together. We manage about $200 million in assets for all of the different entities combined, about 700 accounts in Susquehanna and about 700 in Western PA, so we're fairly evenly matched there. And we do that in a socially responsible way, sharing all those costs across those churches. So we follow the United Methodist guidelines and the social principles. All our investments, our exclusions, our alcohol, our tobacco, pornography, distribution of weapons, anything to do with gambling, that's all screened out of our portfolios, so everything meshes with our social principles. And some of the services that we provide, here, I can see it down here, that'll be a little bit easier. We are set up to be sort of a planned giving office for the church, so to help individual donors that have charitable intent, maybe have a particular gift that they'd like to structure and give to a church in a particular way, they can come and work with us. Also enabling bequests and wills or charitable remainder unit trusts, all kinds of different vehicles. One of our mottos is that we want to help people give more but cost less. So looking for those smart strategies that are going to save people in taxes or just do things in ways that are the most efficient for the donor and then obviously send some resources out into the kingdom of God to get things done in the church. We have educational component to the foundation. Reverend Joe Patterson is retired DS, and he's the dean of our academies. We have a laity academy for financial stewardship and a pastor's academy for financial stewardship, and a third piece that is called Lead Like Jesus. It's an 18-month program for pastors that is specifically focused on leadership in the church and some of those aspects that you don't quite pick up in seminary, but that are centered around organizational management and leadership. Altogether, we have about 70 people engaged in long-term learning opportunities across those 3 academies. And that's at basically no cost to the participants. The foundation picks up the tab and supplies all the speakers and the books and the locations. We tend to use some of our camp and retreat centers. It's just good stewardship. Again, we can be good partners with some places that we already have that are able to stay. So we'll be using Mount Asbury, which I think is pretty close down here, right? Or a little further over. When I was getting off the highway, I thought I had maybe passed the exit for it, but Camp Penn's close here. Okay, gotcha. Okay, neat. So all of those opportunities kind of come as a part of the package of the foundation. Another one, and this is in my portfolio, something I get to deal with, is the grant making program. We're going to have a spring round of grants and a fall round of grants each year. They come out of a fund called the Paul Taylor Ministry Opportunities Fund. The most recently closed round of grants that just happened in October, we are giving away over $116,000 to churches and agencies across both conferences. Those ministry opportunities is pretty broadly defined, so to go through the grant making process, churches maybe just have a new idea is what I usually say. It's like, we like to think of it as seed money to get something off the ground. So we had churches that, we had a lot of technology requests because COVID has changed how people need to do church, and I saw your beautiful system that's installed here, so had many churches that had requests like that too for screens or cameras or maybe new microphones, things like that. And lots of other ones, just maybe getting some after-school ministries off the ground. There were several proposals for those. There's a really interesting one for aftercare for those who are formerly incarcerated. It's a jobs program that's going to be starting up out in Western PA. So I was kind of excited about that one. We're hopeful that that will go well, and that church maybe will share that experience with some others. But they partnered with businesses in the local community. It's going to be like a 16-week Bible study and supper where the men will be, and after the Bible study, they'll also get job skills and learn how to do a resume and do some mock interviews and things that they think will help those gentlemen reintegrate as they're coming back out of prison. So all of those are available. We have some other scholarship funds that we can give away too, and that's all made possible when we have our asset fees for all the fees that we manage. If anything's left over at the end of the year, our policy is we have 12 to 18 months to give that away. So that's, if we run out of profit as a nonprofit, that's where the grant making program comes in. So, and we also have a stable of, we don't so much in-house do capital campaigns, but churches, if they call in with a request, we have some partners that we can point them toward and help them if they're ready to do a building campaign or something of that nature. We talked a little bit about the socially responsible investing. So just again, there's some of the things that we say no to. And that's all screened into our portfolio, and knowing that our dollars are responsibly invested is an important part of our mission. Did I switch it off? I certainly did. There we go. So a little bit about what makes us unique. We exist exclusively to work with churches. So we understand what big church needs are, what small church needs are. We have $1 million accounts and we have $1,000 accounts. Could be anything from an entire church's endowment invested with us, or just a scholarship fund named after someone who passed away in the church and they want to give kids a scholarship in perpetuity. Maybe they set up an account with us, and so we're just all over the place with all different kinds of opportunities in ministry. We only serve institutions that share common bonds and convictions with the United Methodist Church, meaning that as a nonprofit financial ministry, we don't necessarily go work with an individual. We would if you're a donor, but you can't, put any of your portfolio with us and invest. That's exclusively for churches to participate in. And we have specific language in our new bylaws that will allow us to work with any expressions of Methodism. So I know folks kind of get nervous, what's the future maybe going to look like for the denomination, and would your funds be safe if you were invested with us? And the answer is, yeah, that still always belongs to the church. And if there are some differing branches of Methodism in the future, they'll all be eligible to use our services and participate in our ministry. We don't charge any sales charge or commission on the investment side of the house. I don't make any more or less if churches choose to invest with us or go somewhere else. We don't give out any bonuses like you might see at a financial firm. We are a ministry, and that's our purpose, is just to help the churches and help donors accomplish their goals. So that's all we exist to do. So I know we also just really wanted to talk about some estate planning tips today. So that was kind of the general pitch. Thanks for listening, just to know what the foundation's got there. Hopefully, if you heard anything, are there any questions about any of the general parts of our ministry as a foundation? No? Okay. And I'll make sure you know the grant round when it comes around, so keep us in mind. I know that's new for us in Susquehanna. Western PA has had a grants program for several years now, so that's I think going to be a great opportunity for pastors and churches to kind of dream up some new things and have some extra seed money to get that done. So just the basic objectives of today's seminar. Just want to describe what the functions are of a will. I've got some slides with common concerns that people might have. Why is it important to have a will? So the importance of a will. When we think about at the time of death, the church has a lot of ministries that kick in at that point, right? We come alongside a family who is grieving. we celebrate a life. At the end of that life, we remember that that person was a gift from God. We say thank you for that. Offer prayer, and there's really a sacred thing that the church does. And I think that happens at all levels of the church, not just the pastor helping grieving families, but often there's women's groups that might prepare meals and other grieving groups that maybe kick in at that time. And so the church has had a long and historic role at the time of death. And there's an interesting parallel here when you think about planning a will, and we use the words last will and testament. Those are legal terms, but if you also hear in there, that's very Christian language. Your will is really your last chance to give your Christian testimony. And it's been really interesting to see some, in this role, as I've read more and more wills that have been passed down through the foundation, some people really even do that explicitly in their will. Think about what is the statement of faith they want to leave behind. And so, in a way, that's the last chance they're speaking to their relatives and their grandchildren maybe, and they want to say, that Jesus Christ was an important part of my life, and here's why. And so there's even explicit language that you could choose to put in there. You can write anything you want in a will, actually, but one last chance to give your testimony. And of course, that also is a way to say what your values were, what was important to you. A will is protecting your family and taking care of them. It also may leave you the opportunity to give a gift to the church or to a ministry that was really important to you. And so it's interesting to think of it in a spiritual way, not just as a functional document or a legal document, but also a chance to give one's testimony one last time. So now the other side of that is this is a legal document, and so the role of the state is much different from the church. There's differing rules in differing states, but really a will is designed to help you close your affairs in an orderly and organized way so that your debts are paid and things are cared for. Make sure all the taxes are paid. That's important to the government too, But all those pieces, that's really different from maybe the way we think about it as Christians and some giving our testimony at that point too. So statutory requirements, what does it take to make a will legal? One needs to be the age of majority, so you have to be 18 years old to write a will in Pennsylvania. You have to have testamentary capacity, meaning that you're of sound mind when you do that. So, that's sometimes harder to prove, but, as that's being drawn up with a lawyer, someone has to be able to understand and explain what they're doing and why they're doing it. And then of course, a will is effective only if it's been signed. So that's the three as far as what makes it legal. I don't know which makes it legal. They almost always have witness signatures, and I would recommend it be notarized as well. So that's the standard certainly would be those. I don't know legally if somebody were to leave one that didn't have those pieces. I think it would still be legal if it's got their signature, but you're right. Very typically you'll have exactly, that's what you want. You want to say this was done with all the I's dotted and the T's crossed. So that's exactly right. So some of the functions of a will, you have someone called the executor who is going to execute the will. They are there to represent the interests of the person who left the will. So they're supposed to follow out all the instructions to the letter. This can be, sometimes you name a family member or a friend. You can also do this by hiring a professional. A law firm will gladly do that for about 5%. Or sometimes there's a function at a bank where people have left a trust and they can become an executor at the banking institution too. You want to think about this person carefully. If you're selecting a friend or a family member, you want to ask about bonding, whether they could be bonded if they should need to be in that process. So if you have somebody that's had some checkered past, you may not want that person to be named as an executor. So, and you want to make sure you're somebody you trust who has good judgment. You can go with co-executors. You can name two people to work together. That can be an advantage if they have two different skill sets that are going to mesh well together. That can also make it very difficult if they don't get along to make common decisions together. So that's a careful balance there if you were thinking of maybe, sometimes you end up with, two kids out of the family that would, both be in their parents' estate and, you want to think about what frictions you might be creating there and family tensions if that's the best idea or not a good idea, and it really is going to vary situation to situation. You can also, you always want to talk to these people, make sure they're willing to do this, because you can name them, and if they would refuse at that time, then they don't actually have to follow through and do this. You can also name what would be called contingent executors. So if Brian's willing to do it, then he will, and if Brian is not able at that time, then I name Bill to follow through and be a contingent executor. Other functions of a will, that's very important to think about any minor children or any adults with special needs that might require some continuing care, thinking about who is going to be legally able to care for them. You probably have it, Brian, when folks come in to get the baby baptized, sometimes they'll use language of, godparents, right? We just use sponsor in the United Methodist Church, but often people have it in their mind, the godparents, and they think, well, we were here when they were baptized, and they're standing up here with us, and you ask them what that's about, and they say, well, that we'd want them to take care of the kids if anything were to happen to us. Well, that's a really nice sentiment, and it makes for really nice pictures at baptisms, but it has no legal bearing whatsoever. So there will be, in the state of Pennsylvania, a set of relatives that are approached in order by the family court if there's nobody named in a will as a guardian. And just being there present at the baptism is not enough. You do need to have that in writing that they would be willing and able to do that. So, and I mentioned minor children, till they reach the age of majority can be cared for. Sometimes people with special needs children need an even longer term plan for how that's going to look. Split duties. You can give different duties to different guardians in your absence. So if you had maybe a couple of siblings and your brother's willing to take the kids over the summer, he can do that, and maybe your sister would take them during the school year and make sure they're raised and get off to school every day. Yeah, you could split time like that. You can split the duties of taking care of the person versus caring for their finances. So if you had maybe one relative that would be great at raising the kids, but another who would be good at caring for some money you're leaving behind for them, you can also split duties in that sort of way too, and name people to have specific responsibilities. Or maybe one who's going to be in charge of healthcare needs. So can think about all the different ways that could be changed and different. And again, always you want to discuss this with any prospective guardians. You don't want them to be surprised or to be trapped. So, as we're thinking about what younger families in the church needs are, this is an important part of what they might be protecting. So, and of course, contingent guardian, much like a contingent executor, you could name successive sets of people. If they are willing and able, they're first in line. If not, I want you to ask these people, and if not these, and you could set that up as many down the road as you need. So what are the functions of a will? Why does it matter? One of the important things you can be structuring a will for is to try to reduce taxes at the time of your death. And how assets are owned, which assets are gifted, when assets are valued, those can all be functions of a will. There's opportunities sometimes to give a gift to family members before you die, but often that's the worst tax strategy. So as my boss Ed Bailey said, I'm supposed to say at every one of these, don't give the kids the house. Never give the kids the house early. For a couple of reasons. Sometimes you hear the story where so-and-so sold their property or part of the farm off for $1 to whatever. You can create some cascading tax implications that are very nasty out of that because there's a capital gain to be paid there. There are horror stories out there where people gift their house to their kids thinking that they'll stick around and take care of them, and the kids get into some kind of financial trouble, and all of a sudden the mortgage isn't paid and the house is foreclosed on. So that's a piece of control that we really recommend you don't give up the rights to. And also, you don't want to do that because at the time of death, the capital gains get reset on any stocks or assets you own or homes as well. So the value that they have for their future tax bills is much, much higher if you gift it before you die. Whereas if it's given through the will, that's one of the best ways. And which assets are gifted, you can do anything you want in a will to make sure certain things go to certain people. And thinking about when assets are valued, that's an important consideration for maybe farmers, small business owners. Some assets are much less liquid than others, so if you have somebody that's built a business over the course of their lifetime, knowing what the succession plan is and having a part of a will to be able to pass that on, or maybe to even to sell that in a way that's going to capture the value of that business, can be part of planning for a will and the functions of a will as well. Okay, so bequests. That's when you want to give a gift out of your will. That can sometimes be to people, right? First and foremost, you want to care for your family and children. The younger they are, probably the more important that is. Then some people will feel as they get a little further along that their children's lives are more established and they're financially independent. And maybe there's a point where they don't want to give too much to a child that's going to be overwhelming to them. Or so then maybe we ask if there's friends that one would want to remember in your will, and of course charities. Now I'm standing here in the church as an ordained elder, hoping that that's something that people would consider as a gift to their church. But did you know there are far more gifts that go to Penn State than go to the United Methodist Church each year? And you know why that is? They ask for it. That's right. That's right. We're bad in the church at saying to people, remember us in your will. But I think if we would have that conversation more often, we might find that people would think about that. There's often that there are gifts made back to educational institutions or even the local hospital, all places that have a planned giving arm that's making contact with folks and reminding them, remember us in your will if you're able. And we just don't use that language very often in the church. I think that's something we need to, think about and make sure we discuss openly in a way that's not uncomfortable for folks, but just saying, Now, for most Americans, about 98% of most people's wealth is in illiquid forms. So that's in their house, that's in their car, that's in property that they own. It can be in accumulated stock. Lots of people have some that's come from work, and they don't really, maybe they just get the dividend check once in a while, but they've had it for 30 years and it's really appreciated. Those are not, just in your back pocket when you walk into the church and go past the offering plate. And yet, they're the most biggest potential gift that any one of us probably can give in our lifetime is at the time of our death. And with the plan to do it, it's an opportunity to bless those ministries that have been important in our lives while we've been a part of them. So, just some of the things that can go into the probate estate: cash and securities, I was just saying some of those, real property, and all your personal property too. That's all the things you own inside your home. Those can have quite a bit of value too. Sometimes it's artwork that's appreciated for folks. Lots of different things that may come into play there. So it's important to think about that bigger picture. Even if you don't feel like a millionaire, most of us have accumulated more assets in our lifetime than we kind of think of until we take that step back and think about the bigger picture. So it's not just about what's in your checking account, but it's all of those other pieces too. All right. So common misconceptions page. These are some of the things that we hear at the foundation that just turn out not to be true. Like, people would say, I don't need a will because I have a low net worth, right? Like, I'm not a millionaire, I don't need a will. But there are some important functions that a will can do to save taxes, as we've already mentioned, reduce administration, and just really reduce that headache. If you die without a will, there's a whole longer process that everything's going to go through probate, and you're going to leave your heirs with a mess, and not be able to think about those charitable goals that one might have too. So it's important that everybody, whether they feel like a high net worth individual or a low net worth, but everybody really can benefit from the tools that a will can provide. Fill in the blanks. So we have this in here because there's lots of different places, and now it's probably the internet primarily, but you used to be able to go into Staples and buy like a DVD for home will making, and you could go in and punch in a few fill in the blanks and hit print on your dot matrix printer and have your will pop out. We don't recommend that. So I don't know if there's any attorneys in your church or maybe in the town here, but that's certainly something that one needs professional advice and guidance as you're putting together. So we just say, don't, sure there are sites, probably makeawill.com, but that's really not what we would recommend, and loses some of the specificity. Everybody's will really needs its own individual attention because everybody's situation is going to be different, from each one of us to the next. And the tax consequences, they're hard to predict with the fill-in-the-blank ones. So especially if you think that there may be some estate taxes that you want to plan for, that'd be really important time that a professional would want to come to help. Just something for women to consider. Statistically, women are going to live longer. So maybe there are some considerations in a will that one would want to put in there. Thinking about husband and wife and sometimes in more traditional couples, one has always taken care of the finances, and a will might be an important tool if one passes first who's really had the acumen and the savvy in that category, that there's some conversation there and thinking about how we're going to protect the one of us that's left behind at that point. There are a lot of single parents out there, so that would be especially important, that they would give consideration to making a will. It's probably the last thing they have time and energy to do, and yet, obviously, they just a lot of risk there for a single parent to make sure that their children would be cared for. So, of course, there are some singles that make it to an older age that have never been married, and those are some of the most significant gifts to churches sometimes, is the old maid school teacher, She carried her life insurance from the time she started teaching right out of teacher's college. Maybe owns a house in town, doesn't have any direct heirs that she needs to leave money to. The Bump sisters in Binghamton, if you remember them. That was the educational funding. But they were both became two old spinsters together and left a very significant gift to the Binghamton district of the United Methodist Church 100 years ago now. But so just some thoughts there about. And joint ownership, it's important for married couples to think about. Of course, you have joint custody of things when you're married. This is also something that in today's world, there are a lot of couples that aren't married, but are maybe owning property together or even having children together. And so it'd be really important for them to have a detailed plan there so that ownership passes on in the way that you intend it to. Something missing. So joint ownership, sometimes, couples, only one person's carried an asset all that time. So that'd be really important that you're aware of who's on the registrations for things and who's listed on the deed, and making sure that those assets are going to pass to the appropriate person that you intend for them to. So that can be an important, again, there's where professional advice rather than fill in the blank would be really important, just to make sure that things are all really set the way they need to be. Common accident. What did he... I just went through this with Ed the other day. I think I asked the same thing, and now I should remember that answer. I think he was just saying that it's more and more common that when couples are building a life together but haven't been married, that's just gotten more common in today's world, and then the potential for an accident there where things don't pass to, they think, oh, well, of course they would go to, of course they would go to you, dear, but if that's not been in writing, then there can be times where the state would say, well, no, the prescribed formula will pass to maybe to a child or something, and then you find out that somebody loses a home that they thought they would have helped to pay for and be a part of, but they weren't on the deed. Things like that just can be prevented with the right planning. Taxes. We always talk about so much more. So federal, state, and gift tax, I'm going to give you some of the limits here. But you can make gifts to family or friends without triggering any tax consequences of up to $15,000 per person per year. So if you were looking to move some assets on to children before your death, that's the limit without triggering any tax consequences. And that needs to be That should be documented year by year so that later you could go back and say that I was under the lifetime limit in giving those gifts. If you are a couple, you can each give a $15,000 gift to a child or a grandchild. So that's potential of $30,000 a year that would not be taxable. And you can do that to each member of a family. So if you have 2 children and they have, you have kids and they have grandkids, you could give to all 4 members of a household or something. So if you're doing the quick math there, you could give them $60,000 if you're an individual, or you could give them $120,000 a year if you were a couple and you had that much that you wanted to move that way. That will be important too. There are some Medicaid clawbacks that can come into play there, so that's also important. That's documented year by year, that those are intentional gifts. Moving too many assets out of your estate right before going into the nursing home can cause a big headache later. They can come back and try to claw back and say, no, that really should have stayed with the person, and now they have some medical needs or care. So important if you have a plan to give during your lifetime to individuals that you're really carefully documenting how much is being given. So it says included, but I think it should say not included. Outside of that, the lifetime gifts, if you leave life insurance to somebody, that's outside the taxable estate, and employee benefits if you had any residual pension that you want to gift, or 401k, that can be considered outside of your estate as well, those tax deferred assets. So the current exemption, after the last Republican-led round of tax adjustments under the former administration, it went up to $11.7 million. And that's per individual, so if it's a couple, you can double that, and that will all fall under the federal estate tax. So that is a pretty high threshold. There has been some discussion in current affairs that could come back down if Democrats are able to pass it. And I believe in the plans that we've looked at, they're talking about a $2 million cap. So that could be a significant shift in coming years from where you might say, oh, we're probably under the limit. It doesn't really matter. $23.4 million is a pretty sizable estate. But if that were to change, it could come back down to where it might affect far more people. So. There's no federal tax. Yeah, no federal tax. There will be some Pennsylvania ones. I think they might be the next slide here. So. Yep. Here are the Pennsylvania. They take their own bite separate from the federal government, so these limits don't apply. And this, I believe, kicks into every dollar in Pennsylvania. So transfer to your spouse, it is free. But then to a direct descendant, 4.5%. To give to a sibling of yours, it's 12%. And then anybody outside of that family relationship, if you were to just give a gift to a friend, non-lineal gifts, that's 15% that Pennsylvania would charge at the time of that gift. If you are leaving it to child 21 or under, then there's no tax because you're caring for a minor. So important exemption here again, I think I've just mentioned on the last slide, but again, life insurance can be outside of that. So there are some pretty sophisticated strategies that one might try to use some life insurance to leave gifts in ways that are going to be protected from tax, and can be a very useful way to do that. So.
Perhaps an odd question.
Yeah. Go ahead.
Direct lineal, would a daughter-in-law qualify as lineal, or would that be
That's a great question. I think they are considered, if they're married, then I think they're considered to have the same status as their spouse within that. But I can ask that. That's a good, I'll follow up with Ed because I want to make sure I know the answer to that. It's a good one. Sure. Yeah, that's why I think they would have that status. So, yep. So if you were trying to give maybe to, like you said, daughter-in-law to take care for some grandkids, and in the absence of your own, I think they would be considered the same as whoever they married. They would have the same status. So. Annual exclusion of $15,000 per person per year. We already said that's the new year-by-year gift. Gifts in anticipation of death can come back. I already mentioned the Medicaid can claw it back. It's also true if you go to the doctor and the doctor says you've got 6 months to live, and you go home and give away everything that you wanted to give away, those can be considered in anticipation of death and can be contested legally. So again, the will sort of sorts all that out for us. Rather than trying to give gifts prior to your death, making a plan is really important, but being able to use that will can protect so that gifts go where you want them to go, and there's not legal recourse to try to pull that back. And those are the ones where different family members maybe think they didn't get what they expected or wanted, and so a will, again, is a great way to really spell that out and be careful and thoughtful about what you're giving and who. Again, gifts that come through the will, they get what's called the stepped-up basis, and that's a good thing for the person receiving it. So if you have some stock that you've owned, let's say somebody started where I grew up in Wyalusing, it's Procter & Gamble. They give out stock. There's a big plant up there. Worked there in college, didn't get any stock, unfortunately, but folks in my hometown might have Procter & Gamble stock from 50 years ago or 60 years ago. They got it when they started working at the factory. They've never cashed it in for anything. It might be worth, their cost basis could be $1 or $2 on that stock. It could be worth hundreds of dollars today. When you give that gift and it goes through your will, your person inheriting it gets to step up the basis to the day of your death. So rather than saying if they were to sell some, the capital gains would be on all of those dollars, instead they can sell it on the stepped up basis and not have that huge tax bill. So again, it's just about being smart there. Another great, this isn't in the slide here, but another great way to avoid capital gains tax is just to gift stock directly to a charity of your choice. That's another gift I think churches are missing out on if we were to say to more folks that, maybe at the end of the year, they could gift stock to the church, which is something we at the foundation can help you with. We can receive those stocks and liquidate them for you and send the money back to the church. We do a ton of them in December, so this is very much the season for that. But the donor gets the full value of the gift to write off on their income taxes, but they do not pay any capital gains tax. That totally skips that. So there's a great way. Also, gifts out of IRAs can have that same effect. If we ask for those in the right way, again, give more but cost less. That's one of our mottos, is just to help people do that in the smartest way possible. Life income gifts. So this is if somebody has, maybe built up a significant amount of wealth in their lifetime. Maybe somebody who's winding down a business again or a farm. And wants to make sure they have some payment to maybe a spouse or a child for the rest of their life. This would be a life income gift. And we write some of these at the foundation. Helping folks with charitable remainder unit trusts is one of the tools you can use. You have a charitable intent, so maybe you want to make a gift to the church. And so that gift goes into the trust. You get that tax deduction right at the time the gift is completed. But the promise is made by the foundation and through the trust that a certain payment will be made. Usually it's a certain percentage. Will come back every quarter or once a month and come back to myself or to myself and my spouse until both of us have died. And then at that point, that future point in time, the trust will be liquidated and a gift would be made to the church out of that. But that's a way that you can be kind of smart with tax laws there, but maybe provide income and security for somebody that you know is going to need. Those can also be a tool used by folks with special needs children that they know they want to provide for into the future, but really tricky to leave money to someone with special needs, because often they're going to be in institutional care of some kind or another, maybe a group home or something along those lines. They're usually once you find a good one, hopefully, they've made friends, they're settled in, and then somebody leaves a big bequest to your special needs child, and all of a sudden their income's too high to qualify for whatever program they might be a part of. And so you can have these horrible situations where trying to leave money and do good can, maybe disrupt their lives. They end up having to move to a different facility or something because their income's changed. A life income gift can be a way to provide maybe some of those day-to-day needs for a special needs child, but not put so much wealth to them that they can't care for it. But maybe they need a little cash for the incidentals of living life. Well, that could provide them a gift monthly without hitting them with that big gift that would be detrimental to what your goals are in the long run. So, and as I said, you get the tax deduction at the time the trust is set up, because that's considered a completed gift by the IRS. Once you've signed the paperwork, just put it into the charitable trust, then the gift is complete. So, when does a will need to be changed? If you change your state of residence, there will be different rules outside of Pennsylvania. So if you wrote a will in Pennsylvania, but you're going to move to Florida, you'll definitely want to check with your professionals there that you would make sure you have a completed will for either state of residence. Change in financial position, that's kind of broad, but either a big swing up in financial position or a big swing down. Either one of those might necessitate some changes in your will and be an important time to have that conversation. As family members, it could change, that maybe the number of grandchildren you have is going up. That's a good way it might be changing, or somebody else in your family passes away, and that might change what your distributions need to be. So anytime there's major family events, that's maybe a time to just take a look at a will and see if it still accomplishes all the goals that you have. Just talked about tax laws changing. Whether or not that happens in the next few years, I don't know, but there could be significant changes to what end-of-life taxes are going to look like if the parties have their way there. So our best advice is 5 years, kind of at a minimum, and that's also the average of someone who passes away. The average will has been changed within 5 years of a person's death. So it's very common that people start thinking, and they get up there in years, they had some thoughts, maybe, and it makes sense. When you're 40, you have a certain set of goals that you need to accomplish with a will, maybe taking care of some minor children. Get to your 60s, 70s, 80s, some of those goals might change. Maybe your goals in charities change. Maybe Penn State's calling you a lot, and and you decide you'll make a gift to them. But know that it's going to be really, those last 5 years, it's very common that people will make a change. So. Sure. And that's maybe important for churches too. If you do talk about wills with folks, sometimes donors will tell you, I put the church in my will. That's great to know. And then if you can keep some contact with them, that's important. If you think about the last 5 years of some folks' lives, that's when they're not able to get out to church as much anymore. And maybe they move to a nursing home somewhere, and we lose a little bit of track of them as the church. Hopefully we've got good systems in place to care for folks. But that can be a time that a gift you thought was going to be coming the church's way, gets changed in a will where we've lost contact or maybe haven't followed through to say thank you and make sure that, we're still keep in touch. So, charitable remainder trusts, I touched on those a little bit. We can manage those at the foundation, so you'll need an institution that's willing to care for it. Banks are happy to do that too, because they'll charge their fees just like we charge ours, but ours would be responsibly invested. But you're going to basically looking to say, I have a pool of assets now that I want to be distributed over time to care for an individual, and then eventually to make a charitable gift to my church or to some arm of the United Methodist Church or for missions or whatever it might be, however you name that. The tax savings come because the gift is completed, so you get a great deduction up front with that. And then, of course, upon your death, whatever's left in the charitable remainder trust, that's the remainder part that's going to go make the gift at that time. Conditions, I don't remember what I'm supposed to say for that line. So, but corporate or individual, that's just saying a charitable remainder trust can be for one particular individual, can be for a series of people. You could write one that was going to make a payment to every grandchild until they're 21, or until they've completed their schooling, or some inflection point. You can name that. It can be an event in life. It can be an age that they reach. It can be a combination of those things. Where maybe you have some goals to help them get started off in life, and then there's a point where they're going to not need that anymore, or you don't want to give them beyond that, so they're established and they're going to go off and start their careers, and then the gift to the church or to the charity can happen at that time. So lots of ways those can be. They're just very customizable is basically what that slide is to say. If you have some goals, and that sounds like something that could work, there's a lot of ways that they can be crafted to do that for you. So to set one up, you need to draft the papers with the rules for the trust, knowing who all the beneficiaries are going to be. You establish a trustee, like us at the foundation. That's a role we would take. You put your assets in. Oh, I didn't realize this was animated. The assets go in, form the corpus of the trust. It grows and hopefully is well managed by somebody like the foundation, and the beneficiary is going to receive those gifts until whatever time you set forward, whether that's an end date, an age they reach, or upon their death if it's a lifetime. So, questions about a living trust. Sometimes people want to put their assets into a trust while they're still alive. Either not a charitable remainder trust is irrevocable because you've made a completed gift to charity, but this would just be a living trust with the ability to revoke that. So typically this would be somebody that has, these are usually used by individuals that have more complicated structures, like they've owned a business or a farm, or have something a little more complicated that they think this would be a good idea. They still need a will to execute at their death. And there's not really a big tax advantage for creating a trust. So why would you do it? It can be an easier way to manage some things, especially if it's a family business that's been over generations. Sometimes there are some assets that you need to pass along as part of the business, so a trust can be a helpful way to structure that and make sure that there's not going to be an interruption in the farm or the hardware store or whatever it is, maybe a non-traditional asset that you want to pass along. And you can ease that succession for the business and for the family as well. And one other thing that's important is that if it's inside the trust at your death, it will not go through probate, so that will leave a lot more privacy. So sometimes if a donor or an individual has something they want to give in a certain way, a trust can be a tool to keep their anonymity. We just had a church in West that received a $1 million gift. It's a little church with about 10 people attending on Sunday mornings. And so what do you think the first question was when the church council met after they received the gift? Well, who left it to us? Well, the gift was left through the foundation and inside of a trust. So that will not be answered for those church members. I'm sure in a group of 10, they could have their guesses and try to figure it out, but it was the donor's intent. They wanted to remain anonymous. And so that was a tool that let them go through that and, preserve that anonymity even in that small of a setting. So don't ask me, I don't know who it was. But disadvantages, there's some costs to set these up because you have some legal fees to create them. Once they're created, there can be a lack of oversight depending on how you set them up. And even though they have a reputation for having great tax advantages, there's really none. You'll still pay the same taxes of things that were passed through the trust. That anonymity is probably the privacy concerns and the succession of a business. Those are really the two reasons that most often somebody would use it and have a good reason for. So, a couple of other thoughts about documents that you want to have put together as a power of attorney. Can be durable, meaning it's permanent, or specific, meaning it's for this case, either when I'm incapacitated because of X, Y, or Z, or I want them to have control over this part of my finances, but not this part. So make business decisions, but not personal ones, or vice versa. They can be written as specifically as you need. These are really important for spouses to consider writing for each other, especially if there is a health incident that someone needs to be cared through. Powers of attorney can make a lot of things easier if they've been set up ahead of time before something happens to you and you're incapacitated. And again, the joint owners, that's, again, going back to people that own assets together, maybe bought a home together but aren't married. There's another place that you really need to think about how you're going to structure those assets so they stay with the person that you intend for them to. So, powers of attorney die when you die. So, can't write one for that's good posthumously, but okay, healthcare powers of attorney. These can be durable or specific as well if you are going in for a specific procedure. This is becoming more standard. You probably see it a lot at the hospitals, Brian, when you're visiting people before surgeries. The health systems are actually asking you, please fill one out before we even, put you under for this surgery or whatever. So more and more people are having those kind of, but they're just really important that you can designate who's able to make health decisions for you, and that person will have the right paperwork to be able to tell the hospital or your doctors what you want, what your wishes are. A living will is a document that's specific to health care, talking about what services you would and wouldn't want. And so if you've ever looked through one of those, if I were to need to be resuscitated, if I were to need to be in the ICU and have a heart and lung machine, are these things I do want or I don't want, and in what situations would I make those choices? So it can be important for people to think through even before you're in those situations, but especially as different health conditions might come upon you and be a challenge for you, you really have to think through what those details are. And the living will is the document that lets you specify all that, so friends and family are really clear on what your wishes are. And then your physicians also, as I said, the hospitals are asking for them more and more because they want the guidance too, to not have to make those calls on your behalf. And, no chance of recovery. Yeah, so you can use a lot of different language in a living will, but it may say, if the physicians think there's no chance of recovery, then I don't want, extraordinary measures, those sorts of things. So, and the last slide looks like I got all the way to our address there. So I probably talked too much because I've only done a few of these, and I feel like I didn't stop and ask if you had any questions as we were going through. But now that we've come through, are there any sections that you had any questions on, or any specifics that you're interested in? Yeah, that's good. That's good.
I was going to say, we have a trust a woman had set up back in the 1940s, 1950s, 1960s.
Mm-hmm.
At that time, was First National Bank here in Waynesboro.
Okay.
Her brother was the president of the bank.
Okay.
And so she set the trust up there so that the income from that would come to the church.
Mm-hmm.
And semi-annual checks from, it's now different from First National, they're no longer around. Is there any way that trust could be going over to the foundation?
It depends on the language that's in the trust. So if you are the trustee of that,
No, the bank,
the bank probably has it written in a way it's going to stay at the bank. But we're always glad to review documentation with you if that's something you'd be interested in. Some churches, some people leave it in their will that the church has the right to invest it where they want, and sometimes there's specific language that says this bank shall be the trustee, and if they were the trustee and the banks merged, then the new, merged bank will still always keep that in their trust department. So they're not always, and sometimes they're willing to let those go depending on the size too. If the corpus is really sizable, then it's profitable for the bank to manage it. Sometimes the smaller ones, they're more willing than you would realize if you ask, say, hey, we'd like to bring this in-house to our foundation. Sometimes banks actually will, I've never seen them write a big one over, but some of the smaller ones they'll let go of. So.
we get somewhere between $4,000 to $6,000 a year
Okay.
total from it.
So
I know that
corpus must be around six figures then?
if we had our portfolio, we would do a lot better.
Right.
That was just curious.
Mm-hmm. No, good question. If that's something you'd be interested in, when you meet next, if you would like us to have that be reviewed or anything, just let me know.
What would you need from us? I don't have a copy of the trust.
That would be where we'd want to start. So, yep. It would be if there was a separate trust document written, which it sounds like you probably have, because it sounds like they were fairly sophisticated with the bank there. And sometimes you go back to the language of the will. If it was bequeathed to you from that woman, sometimes the language in the will specify some of those. So, and the bank probably has those documents. If you don't have them, that would be also my recommendation is call and ask, can we have a copy? And they should be willing to share that with you. So, yeah. I know that's actually one of our slides, which I don't think was in the deck today, but one of the things that's an advantage for churches is that the foundation will help you keep your paperwork straight. So it's challenging when people come and go off committees and institutional knowledge shifts a little bit. Sometimes it's nice. I do think that's really a strength of us helping smaller churches is say, hey, call us up. We're going to, once we have our hands on a document like that, we're going to file it and we'll have it when you need it next time. So,
Copies of the will that we
yeah.
have.
Mhm.
Gone back and gotten copies of all the wills.
Okay. That's good. I mean, that's always,
Requests, I have a book over here with all of them in.
that's excellent.
We make sure we invest the money or do with the money, the income off of them, what the person intended.
Right, absolutely. And you have a fiduciary duty to do that, so it's really important that you take that seriously. If anybody got mad at you and says to the AG's office that the church isn't using the money the way it was left to them, that can get you in hot water. So,
What you said about the one woman up in North, we had a lady here in town that did housework, housekeeping and that kind of stuff. One of her clients was the president of the land and school company where I worked.
okay,
And he gave her a lot of financial advice. When she passed away, she never was married, no children. She had a $1.9 million estate.
wow,
She left Noah's Ark, our daycare, 10% of it.
wow,
So we get the income off of 10% of, originally it was 190,000.
right, wow. That's a significant gift.
But I mean, there you go. I mean, she was housekeeping.
Yeah. Yeah, there's more stories out there than you'd be surprised. So. Invested, is that still with the bank where it was given, or?
That one there, she set that trust up, yes, it is still with the bank where
Okay.
it's given. So we get 1/10 of it, MCA gets a part. There was, I think, basically about 8 or 10 organizations, charitable organizations, and she gave either 10 or 20% to the different organizations.
Sure.
We reviewed different wills and by the time we went up to the courthouse and some of the wills that were given to, bequests that were given to the church. The one back in 1945, the woman, her signature is in that. She left us $45,000 back in
Wow. That's a good chunk of change in 1945.
1945. That was a big chunk of change.
Yeah. Absolutely. Anything else that we covered or didn't cover that you have questions on?
No,
Good.
yeah.
We've been talking about getting it redone.
We've had several people within the church pass away that did not have wills. One of the lady worked at the bank and she did annuities and everything. You thought she would have definitely had a will, but no will. So
Yeah.
that's why I just think it's important that people have wills.
I think it's important when the church can be courageous enough to say this is important too. And sometimes it's one of those conversations I think too many churches are hesitant to have. Instead, we can be out there with people and say, no, this is a benefit to you, and
And we've seen a lot more people using the tax benefit of direct income coming from their 401.
qualified distributions. Yeah, excellent.
We've had several of them here at the end of the year normally.
Excellent. Yep, that is important that we get that in front of folks too. I talk about that in a lot of different places, and people say, well, what is that now? How do I give from my IRA? And it's really not hard. You just need to know to ask qualified charitable distribution. And some folks are even take a distribution, when it's a forced distribution, which there aren't this year because COVID made an exception, but when they're old enough that they have to take one, sometimes they take that and try to give it to the church after they've received it. Well, they have to pay taxes if it passes through their hands. So yeah, it's just benefit for them and the church if you make sure that people know how to do that well. So
Well, we tried to, a couple of years ago, I put a note in the bulletin about the tax benefit of doing that.
yeah.
From directly from their brokerage.
Yeah, and especially, I mean, I think that should be in every Christmas letter that goes out, just a little box at the side and say, do you know about these? And here's who you can ask. Yeah, come see Bill, ask. But, yeah. Well, thank you very much for the invitation to be here today. Appreciate
Appreciate you coming and sharing.
Yeah. That's okay. Well,